very warm welcome to everyone this evening. It's certainly an honor to be moderating such a distinguished panel that we have here this evening. I'd like first to take a moment to introduce to you the panel. To my right is John Merrick QC. John is one of Canada's most prominent and respected legal counsel. He has provided legal representation on a wide range of high-profile cases, including counsel to the Commission of Public Inquiry into the West Ray mine disaster. He has extensive civil litigation experience and is also an experienced mediator and arbitrator, having studied mediation at Harvard Law School. He is also a part-time faculty member at Dalhousie Law School, regarded by many of his law students as the best teacher they encountered at the law school. John is a former president of the Nova Scotia Barristers Society and lends his expertise to a number of professional and voluntary initiatives. For example, he is honorary counsel for Reachability Nova Scotia. In the middle of the three is Mr. Colin MacDonald. Colin is president and CEO of Clearwater Seafoods Limited Partnerships, and as well co-owner and director of Clearwater Fine Foods Inc. In partnership with others, he has a number of business interests in Canada, the U.S., England, and the Caribbean. Colin is very heavily involved in community-related organizations, such as the IWK Children's Foundation, the Phoenix Youth Programs, and the Abilities Foundation of Nova Scotia, to name but a few. He is a graduate of Dalhousie University and the recipient of 2 honorary Doctorate of Laws degrees, one from Dalhousie University and one from the University of Prince Edward Island. And finally, Sandra MacPherson-Duncan, QC. Sandra is a highly regarded and respected civil litigator and partner in the law firm of Beveridge, McPherson-Duncan, Halifax. She too has extensive civil litigation experience and has appeared before all levels and types of court, up to and including the Supreme Court of Canada. Sandra is a sought-after and frequent speaker in a variety of forums. For example, she was a speaker at the National Civil Litigation Symposium in 2004 and has delivered talks to the Medical Society of Nova Scotia and the Continuing Legal Education Society of Nova Scotia. Active in the Nova Scotia Barristers Society, where she was a member of Bar Council, both appointed and elected. She is also involved in community and civic activities and is a past member of the Executive Committee of the Nova Scotia Hospital and currently a member of the Canadian Executive Service Organization. Those, my friends, are your very distinguished panelists. So the topic for this evening, as mentioned, is trust in civil justice. Let me tell you, as we begin the format of the program, we have asked each of the panelists to provide their thoughts and remarks around 3 questions. The 3 questions are these. Should the public trust the civil justice system? Why has trust eroded, if indeed it has, in the civil justice system? What 2 or 3 practical steps could be taken to restore or improve trust? Should the public trust the civil justice system? Why has trust eroded in the civil justice system? What 2 or 3 practical steps could be taken to restore or improve trust? Each panelist will have an opportunity to address these 3 questions, about 6 or 7 minutes. After each panelist has given their remarks on these 3 questions, each will have a few moments to respond to the other 2 panelists. Following, there will be an opportunity for questions from the audience and the opportunity for a discussion of the various issues that arise. As noted, our topic is trust in the civil justice system. This is a topic that is now and has been much debated throughout Canada and the United States, indeed throughout the world. As will soon become apparent as we begin our discussion, there is often disagreement about what the problems are, what the possible causes are, and how to address or correct the problems identified. It will also become apparent that there are a multitude of issues. One can begin with what is undoubtedly common ground: the importance of the civil justice system and the importance of trust in that system. A civil justice system that is effective and seen to be effective and trustworthy by a broad majority of citizens is essential in a liberal democracy. On that, we can no doubt all agree. Beyond that point of agreement, however, things get dicey. Before we turn to our panelists for their remarks, I would like to make 3 observations in an attempt to describe some common characteristics of the discussion. First, when talking about problems in the civil justice system, there is often agreement that something is a problem, but profound disagreement about how to address that problem. For example, there is a broad consensus that there is a problem with access to justice. Many people cannot afford the time or money to pursue and enforce their legal rights. The Chief Justice of the Supreme Court of Canada, Beverly McLaughlin, recently spoke about this issue at the Empire Club in Toronto and noted as follows, and I quote, "The most advanced justice system in the world is a failure," she said, "if it does not provide justice to the people it is meant to serve." Close quote. There is agreement that the lack of access to justice is a problem in Canada, but there is disagreement about how to address or solve that problem. Second, there is sometimes a failure to see all sides of an issue. For example, it is often said that lawyers are in some way the cause of the problems that beset the civil justice system. This is a perennial, perhaps timeless point of view. In 1770, there was a census taken in the New England state of New Hampshire. The census report for Grafton County, New Hampshire, said the following: 6,489 souls, most of whom are engaged in agriculture. There is not one lawyer, for which fact we take no personal credit, but thank an almighty and merciful God. Now, it may be that lawyers are in some way implicated in the troubles that beset the civil justice system. However, it is important to see both sides of this and every issue. Unlike the census taker those many years ago in New Hampshire, it seems obvious to many that lawyers practicing independent of government control are essential to the well-being of the civil justice system, and indeed the existence of a liberal democracy. In other words, although lawyers may be part of the problem, they are also inevitably going to be part of the solution. A third and final point. The issues that will be talked about tonight are interrelated. Trust in the civil justice system is eroded if there is not access to justice. The cost of litigation is an essential issue that arises in any talk about access to justice. Talk about cost of litigation engages such issues as the role and regulation of lawyers, funding of legal aid by government, and more broadly, the way our society chooses to resolve its disputes. All the issues are interrelated, and therefore any satisfactory resolution of these issues has to be multifaceted. Those are my introductory comments. We now turn to our panelists, and beginning this evening is Ms. Sandra MacPherson-Duncan. Sandra. She will be followed by Mr. Merrick, and finally by Mr. McDonald.
Good evening, everybody. I see a number of members of the judiciary in the audience, and also a number of members of the bar. I hope I don't universally offend all of you with what I've got to say, but I do intend to be frank. So the question is, should the public trust the civil justice system? And in my mind, to answer that question, I look at the outcomes that we as a society should expect from a civil justice system in order to merit our trust. To me, those outcomes are an understandable process, fair resolution of disputes, decisions delivered by competent, unbiased decision makers in a timely or speedy way, and in a way that is affordable to all those who need dispute resolution. So how does our current justice system, our civil justice system, measure up in light of those outcomes? To my mind, it leaves a lot to be desired. It's my duty as a lawyer not to bring the administration of justice into disrepute. I can tell you that those who can afford a lawyer and those with a lawyer who proceed to court generally feel that when their cases are heard, they're heard before competent, unbiased judges. I have no hesitation in saying to you that there are very fine judges in this province, and they do a very, very good job. However, it is said that nowadays 95% of the civil cases don't make it to the courtroom. 95%, that's a staggering number. And faced with such a staggering statistic, it must be apparent to all of us that the court system of litigation that has historically existed in this country may no longer be relevant. The reality is that going to court is too expensive for the ordinary person, and that the length of time from starting a claim until a claim is disposed of by the court is excessive. It's not a matter of months, but a matter of years. And while that clock is ticking, the individual is paying lawyers' fees. Lawyers, including myself, often joke, if I had a problem, I couldn't afford myself. And sadly, that is true. That is true for most of us. The system is seeing an increasing number of self-represented litigants. A conservative figure that I got yesterday from the Prothonotari's office was a minimum of 25% of those involved in civil claims in the Supreme Court of Nova Scotia are now unrepresented. Now, these people present a challenge to the court system, and they themselves feel frustrated at the inability to properly advance their claims, not understanding the process and not understanding when they do get to court how to properly present their claim. As you can imagine, they don't understand the rules of evidence, and any wonder they're frustrated. So for the ordinary person, I would suggest to you, who's looking to the courts for understandable, affordable, speedy, fair resolution of disputes, it's just not happening. This is why I say the trust in our civil justice system has eroded. As well, the legislature has, in some instances, taken away the prospect of a fair resolution of disputes. And we're all familiar with the circumstance where a couple of years ago, a lobby took place by the insurance industry. They complained that as a result of personal injury claims in accident cases, they were either going to have to pull their services from Nova Scotia or drastically increase their rates. And the government responded to that lobby by placing a cap on most personal injury claims in automobile cases at $2,500. And frankly, we all saw the record-breaking profits of the insurance companies that followed. And I don't know about you, but I know my insurance rates haven't gone down as a result. And I'm sorry if I offend anybody by raising this particular topic, but to me, it is a very sore point when I see injured Nova Scotians who do not have proper access to justice in this province. Now, I've got a lot of complaints, and I will say that there have been practical steps already taken to address some of the concerns that I've outlined. As a result of client demand, a whole private industry has developed for alternate dispute resolution, or dispute resolution outside of the court process. If the courts want to take control of this shadow system, and for want of a better description, and make it accessible to everybody, then the courts have to be able to offer alternate dispute resolution to the participants. That is either mediation or arbitration, and they have to do so in a timely way after a claim is started and not years later when a trial is about to occur. Now, as I understand it from speaking to persons in the know, this would require a fundamental shift of philosophy in our sitting judges. And perhaps that's not fair, really. I would suggest that it may need to be imposed politically, and alternate dispute resolution courts or forums be created so that all may have access to this opportunity. Duty lawyers, like legal aid lawyers, might be considered to help the ever-increasing number of self-represented litigants work their way through the court process. Rules of court could be, and I understand are, being rewritten in this province to make them more understandable and precise for everyone, including the unrepresented litigants. And I'd also suggest that the rules of court could also be redrafted to prevent the abusive process which occurs, and I consider it to be unconscionable, when matters are inappropriately dragged out by litigants with resources, hoping, often successfully, that the other side will simply give up. Now, as you can tell, I have a lot of things to say about this particular topic, but I understand I have to share my soapbox with the other participants up here. And I'm going to borrow the advice of Archie Bunker and stifle myself now.
Should we trust the civil justice system? My premise is that it's essential that you do so. Trust in the system that society has for resolving the clash of interests between citizens and between citizens and the state has to be trusted. Think back on the Paris riots of a year ago. In large measure, they were the manifestation of a lack of trust in the system. If there is no trust, and it continues pervasively, it will not be long before the tumbrils are rolling to the guillotine. And that's particularly disconcerting to us in the legal profession because we'll be the first to go. My comments are not unrealistic. When you really think about it, there isn't a lot that separates us from countries where there is unrest because of the lack of such glue. The question is, does it deserve to be trusted? A tougher question. My answer is yes, and I'd give you 3 reasons, the third being the most important of all. First, it's better than the alternative. Duels tend to keep having bodies showing up in community parks, and that's disconcerting. Tribal and clan retribution is disruptive, and there's generally broken glass everywhere. Second reason, most of the time the system gets it right. I'm not aware of any cases over what's becoming a disconcertingly long span of years where I could say that it was a wrong decision. And remember, I was on the losing side of most of those. Nor am I aware of any case where there was political or other interference with how the court carried out its function. I caught just the tail end of an interview this Sunday on the Sunday morning program of a respected, well-established businessman who had just served 1.5 years in jail for white-collar crime. And he was describing the impact that it had on him and his family. And at the end of it all, he was asked by the interviewer, "What do you think of the system?" And he said, "I believe in the system. It's the best that we can have. It just happened to fail me." And that's not a bad assessment. No system can get it right all the time. Let me come to the third reason we should trust it. And this is the important one. And this is the note or the theme I want to try to persuade you of tonight. The independence of our judiciary. We have a bar that has been trained almost inadvertently to question authority and take on anyone. Do you want to sue Her Majesty? Do you want to sue the Prime Minister? Do you want to sue the Premier? Do you want to sue General Motors? Do you want to sue Bill Gates? Do you want to sue, and here it's a little less clear, the RCMP or CSIS or the Ku Klux Klan? There'd be lawyers lined up outside your door, eager for the retainer. I'm not talking here about the characteristic of some lawyers to use any mechanism simply to be adversarial or obstructionist, or who will push any issue regardless of merit. The worst part of my job and the worst part of every lawyer's job is dealing with those kinds of lawyers. I'm talking about skilled, dedicated counsel prepared to fearlessly advocate their clients' positions, even if the cause is unpopular and in the minority. I've speculated how we can be so fortunate. One of the reasons, I think, is that in the common law training, lawyers are trained that the law is not the possession of any one institution, organization, or individual. It resides in the people. But that's a topic for another discussion or perhaps for questions. Because the bench is appointed from the bar, we have in turn judges that are independent and prepared to make decisions that are right regardless of popularity. Decisions that end segregation, that declare basic human values against strong opposition, that restrain the desire of the state to have tools with which to fight terrorism in order to have a balance with basic individual rights. A judiciary that is prepared to render decisions that, to the best of their ability, are the right decision, regardless of whether their houses may be burned, their dogs shot, and their family under the necessity of police protection. And those aren't hypotheticals. Lord Richard Scott, Lord of Appeal in Ordinary, recently said, "There has never been a time since I became a law student in this country in 1955 when it has seemed more important for there to be an independent judiciary, able and determined to hold the executive to the rule of law and to insist on the availability of the justice system to protect individual rights against unlawful encroachment against those rights carried out by the executive in the name of public security or for any other perceived public good. Without such independence, there is no hope of trust in the civil justice system. With such independence, there is ample justification for trust." Having hopefully persuaded you that judicial independence is essential to our society, it would be irresponsible not to tell you that it is coming under serious attack. It is a three-pronged attack. First, there is increasing media criticism of judges, often criticism of individual judges. Now, don't get me wrong, some criticism is expected and indeed healthy. Our courts are involved in more current social issues which put them in the line of ideological fire. To a large extent, it was the Charter that put them there. But there's an increasing and coordinated campaign attacking what is referred to as activist judges. And the phrase is used in a manner that suggests that it is somehow degrading or demeaning. Such criticism is premised on a lack of understanding of the judicial role. It presumes that all a judge should do is apply the law to a given fact situation and the resolution becomes manifestly clear. That's simply not the way it works. There isn't a single case that goes before the court that doesn't have two or more equally valid, plausible, and arguable resolutions that the judge or the court has to choose between. The purpose of such criticism is to pressure judges to reflect a more conservative approach. It has an effect. Professor Wayne McKay of this school gave the opinion in last week's Globe and Mail series that the McLaughlin Supreme Court has become more conservative / perhaps timid because of media attacks. Second prong of the attack. There are attempts to challenge judges for neglect of duty, misconduct, inability to perform duties. We can observe the proposed United States legislation that would permit judges to be sued, the establishment of special grand jury to investigate the willful rendering of an unlawful judgment or void judgment or order. We observe the bill in Congress to establish an inspector general of the judiciary. We observed the Terry Schiavo case, I haven't pronounced that correctly, in Florida last year, when state courts refused to prevent the removal of life support. As a result, the legislature purported to give jurisdiction to the federal courts. When the federal courts refused to prohibit the removal of life support, there was talk of impeachment. What is disturbing about these perhaps extreme initiatives is that they seek to put pressure on the judiciary. There are suggestions of such encroachment here. In a recent letter from the New Brunswick Minister of Justice to the Chief Provincial Judge, there was a suggestion that there be legislated definitions of neglect of duty and misconduct. Now, don't get me wrong. Judicial independence does not mean lack of accountability. But judicial independence cannot be diminished under the guise of accountability. How accountability can be accommodated is a topic for another discussion or perhaps questions. The third challenge is the politicizing of the appointment of judges. Admittedly, the appointment of conservative or liberal judges tends to achieve the result of conservative or liberal decisions. And I use those words with a capital C, capital L, small l. The recent United States Supreme Court decision that was reported this morning illustrates the impact of political appointments. But the judicial role is not to reflect the views of the government of the day. If that was the case, then perhaps all the judges should be sacked with every change of government, much as the way that snowplow operators used to change roles every election in Nova Scotia. It would be equivalent to, in the case of a jury, requiring a juror to declare a predisposition to how they would decide the case as a requirement to entering the jury's box. No, the judicial role is to transcend personal beliefs and ideologies. It is to give an individual or several individuals complete independence from extraneous influences so that they can examine the particular facts of the dispute before them and craft as reasonable and fair a resolution as humanly possible, be it conservative or liberal resolution. For it is in the mix and balance between the status quo and evolution, between stability and adaptability, between differing perspectives that our courts are able to render decisions that are just and reasonable. Martin Luther King said, "The long arc of history tends toward justice." There's something magnificent about that quote, and I would humbly attach a small footnote. That is because the long arc of judicial decisions tends toward justice. Stacking the courts is an attempt to interfere with the mix, to distort the balance that occurs when appointments are made on merit rather than a predisposition of how cases should be decided. It turns the courtroom from the seat of justice to the antechamber of the executive branch. When that happens, the trust will be gone, and justifiably so. I'd go into my next topic and talk about how to correct all these problems, but I'm out of time, and I'll have to wait till questions.
God, I was waiting for the answers. Very serious crowd here tonight. I mean, that's obviously the legal profession, other than the crowd up in the back there. Justice is an extremely personal concept, belief, experience, and it's been the root of all of man's conflicts. At last count, it has about 6.5 billion different definitions. In thinking about trust and justice, I reflect on a postcard I bought a number of years ago, somewhere in the U.S. On it was a picture of 4 or 5 First Nations people, warriors, in battle dress from the 16 or 1700s, with a banner below them which said Homeland Security since 1492. If you accept that the very personal nature of justice, the prime directive in creating trust and justice is how do we protect the right to seek and achieve justice, but not abuse others or the system in the process. To this point of abusing the well-intentioned system set up for dishing out justice in this country and perhaps in North America, some people, organizations, companies have relied on a cost-benefit analysis to achieve false justice in the form of nuisance payments. The abuse has been practiced by everyone, by individuals, by insurance firms, by the government itself, and by large and small companies. Thus you see these ads on television where you have the loudmouth lawyer comes along and tells you he's going to get all the cash you deserve, and sort of reminiscent of the fishmonger going down the street with a wheelbarrow shouting mussels and cockles, alive, alive, ho. Justice is supposed to be decisions rendered by an expert panel and systems after an objective and impassionate evaluation of the facts. However, we all know it's not. Rather, it is an imperfect system, just judgment that sometimes relies far too heavily on questionable skills and competency of politically appointed judges, and I say sometimes because there are obviously very skilled and expert judges in the system, and the skills and experience and diligence of either your or the opposing legal counsel, usually generated by how much money you're willing to pay, Unfortunately, justice to many is both out of financial and intellectual reach. So should the public trust its civil justice system? And I would ask, how can they? Most of us are ignorant of the civil justice, of what justice is, of the system. We're uninformed, inexperienced, and we rely on our exposure to American TV, cop shows, Law and Order, or worse yet, CSI, to believe that that will find you justice. That's why we pay such high legal fees to our lawyers. Judges, too often, as I said, are politically chosen. It appears to be a reward process for services rendered to a particular political party. Lawyers are expensive. The best ones are inaccessible. Large corporations and insurance firms generally have teams of them on staff. It takes forever to get to justice, years. You could be dead by the time the issue is settled. So I guess I have to say no, the public shouldn't trust the civil justice system. Why has trust eroded in the civil justice system? Some of the reasons I've cited: unequal access to justice being more equal for the wealthy. Unfortunately, some of the solutions employed to provide broad access to justice have led to the success of spurious suits. Assured access at little or no cost forces people into a position where you either settle or you pay big fees to get to the end of the equation. Champions for victims of poor and their enthusiasm for perceived justice can burn the innocent. Again, forced to settle suits because it's cheaper to settle than to go through the fight. Unfortunately, this compassion has denigrated the system and trust at a higher level. Attitudes that corporations can pay and that it is fear of corporations or the government is forced to settle what wouldn't be accepted at the individual level. People forget that the dollars that governments have come out of our pockets in the first place, although we cheer the fact that they get sued and the small guy wins. Ignorance, uncertainty of judgment, bad advice, naive beliefs in what the system is and what it can do. Costs. Your costs are in lost dollars, lost relationships, and lost time. And so even if you win, it's a Pyrrhic victory. If I thought of some steps that could be taken to improve justice, the first step would have to be a long-term approach, which is teach it in school. Teach dispute resolution at the earliest age in civic classes, social interaction, morality, and I'm not talking religious morality, integrity, ethics. Make people comfortable with dealing with one another so that at a very early age, so they don't have to come to the court system, so they can avail themselves of the alternative solutions to settle a dispute, be it arbitration or whatever is out there, so that you can have intelligent conversations as opposed to anger and court-driven activities, suing one another. If you do continue into the court system, you need to have guides, individuals to provide objective advice on the system, communicate the ins and outs, some independent informal review process, so that discoveries don't go on forever. You just don't have one series of discoveries after another in the process, so you can't delay the process for months, for years, to wait people out. Insurance companies are extremely good at that. Non-political system of selecting judges. There should be peer review. There should be some sort of testing. I believe in testing at all levels for competency. Judges need to remain current, and just like it's a highly demanding position, and just like pilots, and they should have health checks, eye checks. So legal system individuals need to undergo constant evaluation process of their intellectual capacity, how germane they are with current law. Again, you need to strictly manage the process to minimize the time from start to finish. Costs, people have to understand the cost of going to court. Currently, we don't pay the full cost, or the loser doesn't pay the full cost of being in the court. If you're going to go to court, you should be forced to put something at risk. If it's not dollars, something should be at risk, substantial. And teach people that the courts are the absolute last resort. Use the alternatives. I think private mediation, I know I learned it, the counsel spoke to the fact that the court system was being replaced by a private mediation process, and I think that there's merit in that. I think there is a need for people to settle disputes outside of our tax-supported court system. Our tax base can't continue to build a structure that relies or supports unequal justice. Thank you.
Engaging comments and remarks. The panelists now have an opportunity to respond to each other's comments, and we're going to begin with Mr. Merrick and proceed in the order they're seated to Colin and then Sandra.
Let me jump on that last comment about teaching ADR in the schools. I think that's a tremendous idea, because while lawyers deservedly perhaps take a lot of the responsibility for the delay of protracted litigation, what I find my most difficult task is slowing down my client's enthusiasm to have at the other side. In fact, I was listening to the comments of an Irish barrister recently who was saying that the biggest obstacle he ever had to winning cases or dealing with the situation was overcoming his client. The problem is that clients need to be taught ADR as well, and to be amenable to looking for that kind of a resolution. And the more we can as a society look at ADR as a threshold, I think that would probably be good. The business, though, of setting up private ADR systems troubles me a little bit. If we set up a private medical clinic in this country, there's a hue and cry that it's going to have a tremendous impact on the public system. Today in Canada, you can buy your private justice system. You can get your trial court or arbitrator. You can get your appeal panel. Pick them, 3, 4, 5. What would you like for an appeal panel? Designed to suit your needs. Where would you like to have it heard? What law would you like applied? What's the time schedule you'd like, etc. All at a cost. And what troubles me is that if it got to be too pervasive, may well start to impact the support of the public or civil justice system, as was indicated in the very last comment, that would take the load off, the tax load off our civil justice system. As far as ADR being the role of the courts, I think I would want to discuss that a little bit. I think that everybody got enthusiastic about ADR and decided that that was the way to solve all disputes. It's not the way to solve all disputes. It may be the way to solve 85% of them, but there will always be a core type of situation that has to go to your civil justice system for resolution. Clarification of the law, issues of principle that are involved, sometimes with clients who simply won't negotiate with each other. There has to be that residual judicial system available for resolution. The ADR perhaps can be dealt with as a preliminary to the judicial system, but I don't think we should be turning our courts into ADR itself. I think we should be looking at what the core function of our courts is and should be, and making sure that that's strong, and then the ADR can be an adjunct to that perhaps.
I'm next. Good God. If in fact you can't have private legal clinics or a system for private settlement of dispute, and that's going to harm the overall system, then turn the whole system into a homogeneous package where the lawyers are actually employed by the court. And you, instead of hiring a law firm, and I know this is sort of anti the law firms, but instead of going out and hiring a law firm, one is appointed purely by the court. All lawyers receive a salary from the court. You want to have the tax system pay for it so that everyone has equal access to the system. No one has any cost. I don't have any cost. The fellow who sues me doesn't have any cost. We sit before a court, a judge, 2 lawyers, 3 lawyers, whatever you need on your side, and simply argue the case.
You won't don't realize this, but that raises the vision in a lawyer's mind of doing away with the bloody billable hour. And that would be something I'd almost sell my soul for.
The billable hour. Yeah. Please.
Thank you. As I listened to both of the participants that are sharing this podium or platform with me, I thought of what Winston Churchill had to say, which was, "It's no use saying we are doing our best. You have got to succeed in doing what is necessary." And this particularly applies, as far as I'm concerned, to the civil justice system. No system is good when access is denied to most of the citizens. And that's what exists now in Canada. However, I also appreciate the comments of a businessman, Mr. McDonald, who's sitting next to me, about the need to have an effective method of dealing with frivolous and vexatious litigation. Currently in this province, there doesn't appear to be. Hopefully the rules will be strengthened, of our court will be strengthened, so that frivolous, vexatious litigation can be disposed of at an early time, and the participants don't have to bear the costs of those that don't have an appropriate claim. As I understand it from speaking with the Prothonotari's office, one of the difficulties that the courts face is with, for example, mentally ill claimants bringing cases to the courts. And there's no effective way to refer them to an agency that can actually offer them assistance. The courts know that they're never going to be able to offer them the kind of help that they really need, but there doesn't seem to be an effective way to close the claims of the vexatious or frivolous litigants. So that's what I have to say about that. I certainly don't disagree at all with what Mr. Merrick had to say about confidence in the cases that get to the court. I believe that he said it very articulately, and I wholly support what he has to say. The bigger problem is those cases are essentially for big business and the rich now.